vexatious litigation is taken very seriously, and judges would rather not censor someone who wishes to bring his case before the courts. In California, vexatious litigant legislation defines a vexatious litigant as someone who has filed at least 5 lawsuits in the past 7 years in courts other than small claims. The suits must have been determined to have been made adversely toward the other party, and/or were unjustifiably allowed to remain in a pending status for at least 2 years. This means that the plaintiff never pursued the case to a hearing or trial, keeping the defendant tied to the matter, with no legitimate reason to explain why this never happened. California's vexatious litigant legislation also defines a vexatious litigant as one who repeatedly refiles or attempts to refile a lawsuit after a decision has already been made in the case. For example, a vexatious litigant may challenge the validity of the decision or any of the other issues of fact or law that are made in the case in an attempt to nitpick the decision. A litigant will not be deemed vexatious after filing only one lawsuit. He becomes vexatious after having a pattern of instigating frivolous legal actions over some time, especially not being one of a human right, and violation of due process from commencement, not to mention the entire guardianship should be voided due to its fraudulence. A plaintiff can be found to be a vexatious litigant if he repeatedly files motions, pleadings, or other papers, or engages in the unnecessary discovery, all of which are nothing but a waste of time, adding nothing to the case. These are considered frivolous tactics that are intended to do nothing more than cause delays, and waste the time of everyone involved, from the attorneys to the courts. I am the defendant, not plaintiff. This was all initiated due to Christine Olson, the plaintiff. And my children's safety and return home is not a waste of time or paper. An example of a vexatious litigant is a person who has been previously declared to be a vexatious litigant by any state or federal court. This is especially true if the lawsuit the litigant is filing is similar or identical to any facts or events that have been previously filed. Those who have been found to have filed vexatious litigation in the past are typically required to represent themselves in any lawsuits going forward. This is to prevent attorneys and their firms from risking their reputations and livelihoods in defending vexatious litigation. It is important to note that lawsuits can be considered frivolous after a final determination has been made in the action. Appeals do not count as final determinations, nor do writs, because the existence of an appeal or writ signals that not all avenues have yet been exhausted in the matter. A judgment is final when there is nothing else that can be done in a case. And there is most definitely stuff that can be done in this case. All avenues have not been exhausted. If they had been, and I continued to file a motion, in that case, then I may be considered vexatious to say those motions would be so lacking in value that they are nothing more than an obvious abuse of the legal system. Like this motion of plaintiffs, civil lawsuit, a lawsuit brought about in court when one person claims to have suffered a loss due to the actions of another person. Defendant, a party against whom a lawsuit has been filed in civil court, or who has been accused of, or charged with, a crime or offense. Litigation, the process of taking legal action, the process of suing someone, or trying them for a criminal act. So why am I being told we had already litigated this matter? The only crime is that of the guardians, person who brings a legal action against another person or entity, such as in a civil lawsuit, or criminal proceedings. As explained by the vexatious litigant statute, was enacted because of the problems caused by a persistent and obsessive pro per litigants, which constantly pending groundless actions paling an unreasonable burden on the courts. This, in turn, prevents the speedy consideration of deserving and proper litigations. And I cannot for the life of me understand how I am as undeserving as I had been treated as so, and where my children had been wrongfully kept from me. As this entire guardianship status had been obtained by fraud, deceit, etc. Family Code SEC 3046, and if a party is absent or relocates from the family residence, the court shall not consider the absence or relocation as a factor in determining custody or visitation. The party maintains or makes reasonable efforts to maintain reg contact with the child and behavior demonstrates no intent to abandon the child. So why did this court do that to me? Because Christine lied. The court shall permit the filing of that litigation only if it appears as if it has merit and has not been filed for delay or harassment. Atized and unable to obtain the equal protection and procedural and substantive due process guaranteed under the 14th Amendment. By not denying the parents the ability to apply legislative interest of the best interest child standard, the court held that in such a case then, if a defendant has abused the judicial system in the past, a plaintiff, the defendant must be permitted to defend himself as any other defendant would. Atized and unable to obtain the equal protection and procedural and substantive due process guaranteed under the 14th Amendment. By not denying the parents the ability to apply legislative interest of the best interest child standard, the court held that in such a case then, if a defendant has abused the judicial system in the past, a plaintiff, the defendant must be permitted to defend himself as any other defendant would. Courts have the constitutional obligation and the inherent powers to protect against conduct that impairs the court's ability to conduct their functions where vexatious conduct hinders the court from fulfilling its constitutional duty. Constitutional, a law or regulation is in accord with the principles outlined in the Constitution of a nation or a state. What is a constitutional obligation to a court of law? The U.S. Constitution is the nation's fundamental law. It codifies the core values of the people. Courts have the responsibility to interpret the constitutional meaning, as well as the meaning of the law passed by Congress. Nor does this conclusion, by any means, suppose a superiority of the judicial to legislative power. It only supposed that the power of the people is superior to both, and that where the will of the legislature declared in its statutes stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decisions by fundamental law rather than those which are not fundamental. The American democratic system is not always based on simple majority rule. Certain principles are so important to the nation that the majority rule. Certain principles are so important to the nation that the majority has agreed not to interfere in that area. For instance, the Bill of Rights was passed because concepts such as freedom of religion, speech, equal treatment, and due process of the law were deemed so important that barring a constitutional amendment, not even a majority should be allowed to change the rule of law under which all persons, institutes, and entities are accountable to laws that are publicly promulgated equally, enforced independently, adjudicated, and constituent with international human rights principles. The courts play an integral role in maintaining the rule of law, particularly when they hear the grievances voiced by the minority groups by those who may hold minority opinions. Equality before the law is such an essential part of the American system of government that when a majority, whether acting intentionally or unintentionally, the factors to be considered in evaluating whether or not to issue a pre-filing injunction are 1. The litigant's history of vexatious litigation. 2. Whether or not the litigant is represented by counsel. 3. Whether the litigant has caused needless expense or unnecessary burdens on the opposing party or the court. And 4. The adequacy of other sanctions. 5. Ultimately, the question the court must answer is whether a litigant who has a history of vexatious litigation is likely to continue to abuse the judicial process and harass the other parties. Any trial court in the state may order a party, the party's attorney, or both to pay any reasonable expenses, including attorney's fees, incurred as a result of bad faith actions or tactics that are frivolous or solely intended to cause unnecessary delay. Frivolous is defined as totally and completely without merit or for the sole purpose of harassing an opposing party. Cal Code of Civil Pro, Section 128.5. It is not being presented primarily for an improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation. 1. I have no vexatious litigation history, in fact no history of litigation at all. 2. I have absolutely no choice whether I have representation or not. There is no one to represent in this matter. The selection is quite scarce. 3. No cost issues for Christine Olson. She is as well pro/say litigant. There is non-cost for her. 5. Again, no history of litigation, and I have not abused the systems of law. In fact, Guardian has by filing false and fraudulent documents and consents, she is in fact the one frustrating the process. Now if this court had intended to state that I had been disrupting the court process and invading its ability to do its constitutional duties, then you would be permitting the culprit to get away and do just this beneath your nose, and not bat an eye. Might I remind this court that I had received a threat 1 year ago to abolish me should I come back to court or mention Christine Olson's criminal past yet again. However, does this court not realize I had only helped point out the fact they had missed, since Guardian self-reported never been arrested, and she clearly lied and a background check had clearly not been done on Christine, before permitting her to care for my children, in which she has failed her duties as well. One simply does not become a vexatious litigant for 2 petitions in their life, and with good intent behind said motions. The return of a mother's children I believe to be nothing more than a good faith move for parent, especially because it is such a sacred liberty and had been wrongfully removed and kept away from. So if this court considered my vexatious litigant, I will then know it was just a cover-up for a previous hiccup that the court system refuses to admit, to avoid their own punishments in the end. So who do they target, and with what? They target the one who is actually getting harassed, who is actually being honest, who actually has that superior right of child rearing and human right naturally as mother, and has never been deemed unfit and has unlawfully and unjustifiably been subjected to a harsh and cruel punishment, such as not being able to file again to fight for my rights and mothering and reuniting with my children who have been wrongfully kept from me by some third party whom is questionably unsound. And permitting the one who plays the victim, and is obviously the perpetrator, to abuse the system of laws, walk all over and make a mockery, make a moot of it all, and further damage my children in all the worst ways that define the exact opposite of best interest standard. That is judicial process of impartiality to this court? Let's reverse the thought process. There is nothing logical about this. This is what's the truth here. Investigator Julio Quinones, he is now gone. However, his dishonesty in his reports and recommendations still remains, and my name remains tainted by his highly erroneous and degrading opinions that deformed my character right alongside Christine Olson and Joshua Ludwig. Doing the same as a mother who is anything but undeserving gets thrown out of her children's lives, for no justified reason, and those children, my children, they are forever damaged by the same frivolous and unacceptable acts in which these parties acted upon, and I am sitting here unable to correct the mistakes and unable to save my children who need me because I had not even been provided a valid copy to reply because the time limit is now up on replying, because I was not told about this. Guardianship happening until 6 months had gone by and Christine had gotten her way to sweep her absolutely fabricated and ridiculously untrue stories across the entire face of this court and its people before I had ever had an opportunity or fair chance to defend those wrong brought against me. I'll let you in on a little secret. Christine, she had painted a perfect visual of herself when describing me. I am told 1 year ago, the court will abolish me and declare me as vexatious litigant if I come before the court once more or mention Christine Olson's criminal past. Now, currently the same threat arises once again, but not through the court's doing, but Christine's, and in a retaliating reply to my request to terminate her as guardian of my children. This was not her place to bring this to court, as it was the court's place and responsibility, as they had initially made this threat on me, not Christine Olson. She is not the court, nor above any other. She inherits no special powers, as she can't even fulfill the duties in which she is required and sworn into, by having the dignity, respect, kindness, and having those children's well-being in the best of her heart. But however, that does not appear to be the case here, and that is very upsetting in itself. If the court had wanted to deem me as vexatious litigant, it would have done so on its own period. Instead, I had then been granted another termination of guardianship 1 year later, my second motion/action move I have ever made in this court, as I am quite certain the declarations are not considered any legal action being made because it does not commence a court hearing. There was no intent to harass, annoy, nor belittle any party. I am on the mission of prevailing and getting back my children, whom are just this, my children. Not Christine's. You cannot simply gain custody of one's children illegally, forge documents, collect lump sums, and exhibit now a more extravagant lifestyle, isolate children, and entirely cut out all contact from every one of those children, and whom they have always known, and still expect yourself to be off the hook and incapable of being expected to damages and punishment. Not one person who does another wrong life a life with such luck struck their way in the more fortuitous lifestyle forever. The truth itself prevails, and I do believe Christine knows I am unraveling the truth, and as I do this, she then retaliates even more drastically, because she cannot handle the thought of being defeated, although she knows she did wrong, and she can feel it coming, that others will soon see it as well. There has been nothing legal nor honest in regard to what Christine Olson has ever filed or said during this court-involved stage in life. The actual and intrinsic rights and wrongs of an issue, ESP in a law case, as distinct from extraneous matters and technicalities. However, when I had pointed out to the court, I was threatened. I was just showing the court that Christine in fact did have a criminal history, as she had self-reported never been arrested within her report and recommendation page, where I had found upon educating myself on the matter that a confidential screening form is required for each proposed guardian, in which is form GC 251 page 1 of 3 notice to guardians, failure to complete, sign, and return this form will result in further court action, possibly including your removal as guardian. A guardian who willfully submits any material information required by this form that he or she knows to be false is guilty of a misdemeanor page 1 to 2 screening form GC 212 number 3. Page 1 of 2 the questionnaire asks, I have or I have not been charged with, arrested for, or convicted of a crime deemed to be a felony, or a misdemeanor. Christine Olsen had put she had not. Clearly it states just this on Julio Quinones' report and recommendation in August 2020. Christine Olsen, self-reported, never been arrested, then contradicts itself later on by stating she was convicted of a minor misdemeanor charge, yet I had seen her mugshots, presented her mugshots, and no she was not guilty of any misdemeanor by this conduct of lying under oath. However, if anyone else had, that misdemeanor would have been pasted upon a party quicker. Then we could turn our head the other way, guarantee that. This system has shown to my equality of being parent nothing but inequality and insufficiency in its very process, and this goes as far back as day one when Christine had submitted her first petition for guardian, and she states that I could not be reached, so she could not have me served, therefore she just called it good enough, and the courts accepted it as just that. If somebody here could please pay attention to this case as it desperately needs it, will then clearly be seen that. Christine had stated I was on the run from law enforcement, I could not be served, but immediately following it states I told her online, she agreed to sign the consent. How did she get that answer out of me? As well inform me of this happening, if I was unreachable on the run from the law. Those involved certainly make it difficult to not have the thought that there is something suspicious happening here, such as Mrs. Brooks, child advocate, who alongside Mr. Quinones had lied to the judge herself, and within Exhibit L, 28, you will clearly see why I am. What did Mr. Quinones say? Questionable of the process. Absolutely, I pray this court will do what is correct and return my children home where they are safe from the abuse, suffering, and damaging cause and effects brought by guardian and her husband Adam Lure, and brought back to my care and custody where they will forever be loved and never again hurt, where they rightfully belong. The mission of the Butte County Superior Court is to create a court environment deserving of community respect by resolving disputes according to law, ensuring and protecting people's rights, taking a leadership role in preserving order in society, and providing exceptional, accessible, and fair justice services to all. If this court were to approve this motion of plaintiffs to declare me as vexatious litigant, I would be wrongfully be declared vexatious. Respectfully submitted June 20th, 2022. Michelle Olsen defended in Pro Per. 1. Civil Code, Section 1570.